Good morning, everyone. Madam President, distinguished representatives, delegates, and observers. I would like to thank the Human Rights Council for this opportunity to present my report, my last report, as Special Rapporteur. This year is the 20th anniversary of the adoption of the so-called Palermo Protocol, the main international instrument against trafficking. It is my belief that it is time to reflect on the implementation of the protocol and related national legislation, their main gaps, as well as on the way forward. The adoption of the protocol in 2000 mobilized enormous energies worldwide. However, inconsistencies in relation to human rights standards were highlighted by experts, academia, and civil society organizations. Moreover, implementation of national legislation not always fully complying with the protocol has often produced further violations of the rights of persons concerned, such as their detention in so-called closed shelters. Despite the adoption of the recommended principles and guidelines on human rights and human trafficking, today anti-trafficking legislation and policies remain shaped by a strong law enforcement approach, with little attention paid to the rights of the person concerned. Moreover, the increasing trend toward criminalization of irregular migration is a driving factor of trafficking. Restrictive migration policies and xenophobic or racist approaches to migration exacerbate or even create vulnerabilities to trafficking and exploitation, as undocumented migrants, including trafficked persons, fearing deportation, are often induced to accept exploitative conditions. Some results have been achieved, especially regarding trafficking for sexual exploitation, and especially in countries where cooperation with civil society organizations have been established and they have been adequately funded. However, in the field of labor exploitation, we are still in an early stage. Furthermore, a lack of dedicated procedures to promptly protect victims and potential victims in mixed migration flows leads to further exposure to different forms of exploitation. Therefore, today, anti-trafficking action remains limited to a specific area of law enforcement activities, while massive exploitation occurring in many economic sectors goes unnoticed and is becoming a systemic component of our economies worldwide. The rampant exploitation of vulnerable workers, among them many women and children, has become even more severe during the pandemic COVID-19. People losing their jobs and reduced to starvation, for example in the touristic industry or in domestic work, mostly women, are induced to accept even more exploitative working conditions. On the other hand, people working in sectors considered essential during the pandemic, such as agriculture or transport and deliveries, have been obliged to work under pressure, even longer working hours, and without appropriate safety measures. Children in emergency situations very often become the only source of income for their families and are subject to the worst forms of child labor. The impact of the pandemic confirms that the trend is still, and even more today, toward increasing severe exploitation, including in the context of trafficking. Against this background, I'm convinced that a true shift is needed in the prevention of a fight against trafficking, which should be genuinely inspired by a human rights agenda to be really effective. You will find in my report some recommendations that have been conceived as an update of the recommended principles and guidelines, especially taking into account experience gained by relevant actors and especially civil society organizations. My recommendations address all forms of exploitation, with a particular attention paid to labor exploitation. Madam President, I would like to highlight a few essential points. First, the rights of trafficked persons can be protected only if migrants' rights and workers' rights are protected. This requires the establishment of significant and accessible regular channels for migration, which is essential to reduce migrants' vulnerabilities. Firewalls should be established between access to services and immigration checks. Recruitment and intermediation agencies should be controlled. Recruitment fees should never be charged on workers. Second, Dedicated procedure for protective purposes are needed to identify vulnerabilities to trafficking and exploitation, especially in the context of mixed migration flows. Third, early support to trafficked persons and persons vulnerable to trafficking should never be made conditional on the initiation of criminal proceedings or on the willingness or ability of the person to cooperate with law enforcement authorities. Fourth, support should aim to full social inclusion of the person, which can be achieved through long-term measures, including education, training, alternative employment, skill acquisition, and tutorship. Such a process should have a transformative nature, should not reflect gender stereotypes, and be based on real interests and aspirations of the person. This is absolutely essential also to prevent re-trafficking. Fifth, states should establish reporting obligations for businesses, including in relation to their supply chains, not only regarding actions taken, but also results achieved, including risk identification, plans to address such risks, and to provide viable solutions for workers losing their jobs as a consequence of termination of contracts with suppliers. Companies should be held responsible for damages when not complying with such regulations. Sixth, businesses have their own due diligence obligations and should act effectively on a voluntary basis to minimize risks, detect and address exploitation, including in their supply chains. Seventh, trafficked and exploited persons are entitled to remedies, including compensation, that states should ensure through penal, civil, and labor law judicial procedures. In addition, businesses should establish grievance mechanisms in cooperation with trade unions and civil society organizations, not only in order to detect exploitation, but also to provide workers with an effective and quick procedure to have their salaries paid. Finally, and importantly, the non-punishment principle should be correctly implemented, as comprising all cases in which trafficked persons cannot act with free will, not only because of violence, but also because of the abuse of a position of vulnerability. Madam President, let me finally point out the main message of this report and of my 6-year tenure. It is essential, in my view, to shift from a criminal law approach to an approach in which trafficking is considered primarily a human rights and social justice issue, and in which empowerment and social inclusion of trafficked persons and survivors are the final goals of any anti-trafficking action. Madam President, I now turn to the country visit I conducted to Montenegro from the 1st to the 8th of November 2019. I thank the government for its cooperation prior, during, and after the visit. First of all, I commend Montenegro for its commitment in combating trafficking in persons, as evidenced by inter alia strong focus on prevention among communities at risk. In addition, I made a number of recommendations, and I am pleased to learn that the government has, since my visit, considered my recommendations, especially regarding the approval of the standard operating procedures developed in cooperation with IOM for early support to trafficked persons. In my report, I had expressed my concerns about, among other things, the low number of victims identified and supported, and the low number of criminal proceedings. Hopefully, this trend will change. I was made aware, after my visit, of the identification of a higher number of victims, and it is now in the government's hands to make sure that these trafficked persons receive support and their rights are fully protected. I thank you all for your kind attention, and I look forward to a fruitful interactive dialogue. Thank you.